All right, so it is Wednesday, January 13th, I believe. And this is Senate Government Operations. And yesterday, we had a little lesson on kind of running Zoom meetings and how to make them more effective. So I'm just going to share a couple things with you. And I think that we'll try to do this in an abbreviated version at the beginning of most of the meetings, just so that everybody who's joining us is aware of what it is. So one of the things that we talked about was because the format that we're using, it's easy for things to kind of get out of control. And so I'm going to be more forceful and meaner than I usually am in our in-person committees, and try to, so that we can keep things under control. And I would expect everybody to be civil and respectful and to listen carefully to each other. So a few things here. If everybody, some ground rules. First of all, there are, I believe, 4 different types of people joining us. There's committee members and staff, the attorneys and Gail that are here, and we're the ones that are having the conversations and making the decisions. Then there's people we've invited as witnesses who will give us their perspective on issues. Then there are those in the room who might be in the room as observers. They're not necessarily witnesses. They haven't been asked to testify, but they're here as observers. And then there are those people who are watching on YouTube, if anybody is. So there are really kind of 4 different types of participants. So what I would ask is that, and committee members, you don't necessarily have to keep your mute on unless you have noise in the background, or because it's easier to, if you want to speak, but, or if Isabel is there barking away. But Isabel is our mascot. So, but I would ask everybody else to keep their mutes on. I guess that's the way to say it. Keep themselves muted. And I'm not going to, I do not want to have people using the chat function, because if people are in the room, they do not necessarily have the ability to chat with us, because we're in a committee meeting, and people who are observers do not have the ability to chat. And I would ask us also not to use chat, just because and if you disagree with that, we can talk about that. But Senator Rahm?
Madam Chairwoman, you can disable chat. You can have Gail disable the chat, so no one can use it.
Oh, okay. I did not know that. I was just asking people. So Gail.
And Madam Chair, I find the chat really helpful to send messages without disrupting the meeting like I am right now. So I have a definite use, a specific use for that chat function.
Okay. I would ask the rest of us not to use chat. Senator Clarkson?
Gail, I love that you use it. I can't see it. It's too small, and
You're not going to use it.
No, but Gail's communications, Gail, I'm not going to be able to read your chats.
No.
So if you're sending something to me.
No, Gail, I'm not sure how you use chat, but don't use it to send messages to us. Okay?
Right. Text us or something.
No.
I can see a text, but I can't see a chat. It's too far away. I can see a text here. Chat is like, I have to go like that to read it.
Okay. So committee, let's just back up one step then. Gail, how do you use chat?
I use chat to post links to documents when it's something the committee is discussing and is trying to find.
That's fine.
I use chats to alert people, sometimes such as you. Like I emailed you today that Commissioner Sherling has a hard stop at 3:15.
Right.
And sometimes I will use chat to make people aware of that. So it's usually regarding the mechanics of the meeting.
Well, that's the only thing that I would use chat for. And I think if you're posting documents and stuff, that's fine. Well, Allison, she can
But-
take,
Posting documents, aren't you posting documents onto our website, which we can read on our computers?
I'm putting links on chat when people are having a hard time locating that document.
yes. And I have to admit that I don't look at the chat function. So if you're sending something, if there's something that really needs to be, that we really need to be paying attention to, just put your video on, raise your hand.
Okay.
But I think for posting links to documents and stuff, that does make sense. But I don't think that we don't want observers or anybody else using the chat function, and we shouldn't be using it either. I believe, because I think that whatever we have to say, we should be saying it. Does that make sense, committee? Okay, thank you.
Thank you, Madam Chair.
Thank you, Gail. So with that said, I think we only have a couple people here with us today, and right before we're going to do two things. The first thing we're going to do is vote. We're going to take up the town meeting bill. And I have to say that I don't know where the message came from, but I have been, just in the last 20 minutes, have gotten about 10 bazillion emails from towns who say, don't make us do it, don't make us do it. And I don't know why they think that we're making them do it, but there is no move to make anybody do anything. Gwen, yes, Gwen.
Thank you, Madam Chair. This is Gwen Zacca from VLCC. So there was a floor amendment or not a floor, I don't know if it was in the calendar,
Yes.
but there was an amendment from a St. Albans representative in the House that had mandatory language in it. And then today we had heard that there would be potentially a similar amendment put forth from that Franklin County area. So we had put a message out to our members, just, not to go against what your committee has done, what the House Government Operations Committee has done, but to support what you're doing and to oppose any potential amendment. So I apologize if there's an inundation of emails, but it does go to show that they are paying attention, and it's really important to have that flexibility. So that's where it came from. And it's in support of the H48 as passed, and in opposition of any amendment that would make it mandatory.
Okay, thank you. I think what I heard here from towns is that they think the governor is going to have us mandate it. But as far as I know from Kendall yesterday, the we've always known that the governor would have preferred a mandate. And the governor's office has made that clear. But from what Kendall said yesterday, they are happy with the way it turned out and will support it. So Senator Collmore?
Yes, without giving away any confidential information, I did just meet with the governor prior to the floor session. And as far as I know, there will not be any move on the administration's part to change anything in the current language of H48. We should pass it without amendments on this side. It will then be sent back to the House because it's their bill, and they will get it to the governor. The only thing that the governor asked is to make sure that Ledge Council was fully aware of the need for immediacy in this respect, so that they looked it over and it didn't take an extra couple days to go from Ledge Council back to the governor. And Representative McCoy, who's the House Minority Leader, agreed that she would make sure that happened to the best of her ability.
Good. Thank you. That's where I thought we were.
Yep.
So, okay, great. I just wanted to make sure that we said that publicly here. So given that, Does anybody have a motion to make? Brian, Senator Collmore.
Thank you, Madam Chair. I move that the committee votes out H 48 as it came over from the other body with no amendments.
I'd second that.
Okay, so Senator Ram, would you like to call the, what do we call this?
The roll, the
The roll.
record of action. Yeah.
Yeah, okay.
Yes, I would be happy to. Senator Clarkson,
Yes.
Senator Collmore,
Yes.
Senator Polina,
Yes.
myself, Senator Ram, yes, and Chairwoman White.
Yes. Thank you, everybody. I think that, and we will get this, I will report this unless somebody has a burning desire to. Okay, I will.
I hear a song, Burning Desire. I'm waiting for Collmore to break out into song. I feel like Frank Sinatra's coming on somewhere. Or Johnny Cash. Is it Johnny Cash? Or
No, he was a ring of fire, not a burning desire.
Oh, Dream
Yeah.
of Fire. Well, you
Yeah.
could rewrite the words.
I was
So-
racking my brain for a title called Burning Desire and it wasn't coming to me.
Oh, yeah. Right. Well, Desire, Fire.
All right, so let us, I think the way this works now is that Tucker makes sure that Gail has a clean copy and there are no changes. So you will send that to Gail and I will send it to Secretary Bloomer.
And I will send this to Gail alone, the record of action.
Okay, I don't know how you work that out, if you're going to send it right away or mail, I don't know, but that's up to you.
Damn it.
And Jeanette, when you send it to John Bloomer, you have to include the vote and all that.
Yes.
The committee
Yeah.
vote, yep.
Okay,
And I will provide the reporter with a list of witnesses.
oh, great, thank you, thank you. Okay, so that is our first bill. Good work, everybody. Yes, Senator Collmore.
Thank you, Madam Chair. So I assume it'll come up on we haven't had a Senate calendar still because I guess there's been no orders of the day. I
Right.
take that to mean, so tomorrow, will you be making the motion to suspend the rules and bring it up for immediate consideration?
I don't know if I will or if Senator Ballant will,
Okay,
but we'll figure that one out, however it makes the most sense to do that. I think maybe it's the pro tem that would make that motion, but I'm not entirely sure. But we
Okay.
will be making the motion to take it off the calendar tomorrow and advance it through all stages. Okay, great. Okay, thanks, everybody. So now we have another issue that was brought to us by the Attorney General's office. And it is kind of out of our bailiwick here, but because it involves public records, we're going to look at it, and then judiciary is also going to look at the issue from the court's perspective. And the issue came about, I've been asked by some people if they could join us. I do not see David Scherer here. And I know Mike Donahue also wanted to join us, but I don't see them here at all. So the issue came up around, I believe it was a 16-year-old in Burlington who was involved in a fatal car crash. And the name, it's a little bit unclear here where that case ends up. Does it end up in adult court or in juvenile court? And when it's in juvenile court, it's confidential, but when it's in adult court, it's not. So how do we, if something ends up going to juvenile court, how do we protect that from the very start? So it is a matter of public records. And I think that what I'd like to do here, I think, is since Commissioner Sherling has a hard stop, and also because I think he is a little busy doing a few other things trying to keep us safe here, that I'd like to start with you, Commissioner, on, because I think that when you were approached with this, you looked at the public records law and you looked at your internal policy and no, wait a minute. I think that we have a little bit of time. I think I'd like to have Tucker just talk to us a little bit about the public records law and the exemptions. Is that okay, Commissioner?
Certainly, Madam Chair. I have plenty of time. I have over an hour.
Oh, okay. Thank you. So Tucker, if you'd like to just give us kind of a once over on the public records law and how this is impacted.
Sure. So good afternoon, Tucker Anderson, Office of Legislative Counsel. I have not been fully briefed on what the particular issue at hand is, but I can give you some idea of where tension may exist between public access to arrest records in general and the confidentiality of some juvenile court records.
Mm-hmm.
So under the Public Records Act, specifically in 1 VSA Section 317C5, there are a series of Public Records Act exemptions that relate to law enforcement investigations. As part of that particular subdivision and the exemptions that are applied to specific law enforcement records, there is a clause that states that records relating to the arrest of a person shall be public. So I'm assuming that that is where the tension in the law is being based right now, that those arrest records are available. And the term that is used is the arrest of a person. So it doesn't set aside in the general law records related to the arrest of a juvenile. In Title III, and I apologize that I cannot recall offhand what section it is, there are a series of confidentiality provisions related to juvenile diversion proceedings. And under that title, there are confidentiality and sealed records provisions related to juvenile proceedings. So those court records are sealed, and I believe that the law requires that if there is a request for those records, not only are they confidential, but the agency that is responding to a request for those specific juvenile proceedings must respond by saying, no records exist. That is the response that they must give. Outside of that, there's an additional realm of records that you're dealing with here, and those are court records, potentially. Perhaps that's what Patricia Gable will be talking about today. But court records are additionally covered by judiciary rules governing access to court records. So there's some other considerations there. I hope that adequately tees up the issues. I'm excited to hear the testimony today and get a better idea of what the tension might be and what the solutions could be moving forward.
Yeah, I think that you did a good job of teeing that up, and it was exacerbated, I think, when we moved the ability for some older people to be treated in juvenile court as opposed to adult court, and we've kind of gradually moved that up. So I think that made it even more complex here. So does anybody have any questions of Tucker right now? All right, okay. So Commissioner Sherling, then if you want to talk to us about how, because I know that you felt that looking at the law and at your internal policies that you needed to, it was a public, it had to be accessible to the public. So if you would just talk to us a little bit about that. And if you have any.
Actually, for the record, Mike Sherling, Commissioner of Public Safety. So a couple important starting points for the record. To begin, the Department of Public Safety does not have a specific position relative to the records, but we are in agreement with the Attorney General's office that there's an incongruity in a variety of the different statutes that bang into each other around what's public and what's not. So this is really an effort to ask for clarity. And to that end, I sent about an hour ago just an outline of some of the legal components that our general counsel put together. So for the committee's benefit and for Ledge Counsel's benefit, to be able to see those without me just listing them off. And then at the end of that document, some additional considerations that are, I think are just important to flag for the committee and ultimately for the General Assembly that don't necessarily relate to the statutory overlay, but are just issues that you should be aware of relative to records in general, but in particular, this tension on juvenile records. So the simplified, to the greatest extent I can simplify the conflicts here, they fall into, I think, 4 general lanes. First is the general premise that the records of government action under our Freedom of Information Act law are public, which is, and there are a variety of exceptions that are laid out there, but that's the starting point. There are, the conflicts come in when you begin to unpack other parallel pieces of legislation that appear to have been designed to protect juvenile records in particular. So starting with Title 33, Section 5101, juvenile proceedings, at the time that was drafted, they were in juvenile court. They're now in family court, are protected. And there are specific provisions that say we can't provide any publicity whatsoever about those kinds of proceedings. So that's reasonably clear. What then becomes interesting and a little bit muddy is, let's say, for example, Jane Smith is a juvenile, is involved in a car crash. And we do not yet know whether Jane Smith is going to be in court for any charges related to that car crash. The juvenile law clearly says we can't give any publicity to that. There are other conflicts in the motor vehicle law that clearly make accident reports and tickets public facing, and those are for good reason. The insurance system wouldn't function without those things being public facing. And probably more overarching than that, the privilege to operate a motor vehicle is just that. It's a privilege issued by the state, and part of what you're giving up when you choose to exercise that privilege is a cross-section of your privacy interests relative to whether you were involved in an accident or received a ticket. And for juveniles in particular, your parents are signing off on your privilege to operate a motor vehicle as well. So there's an incongruity there. But so take this example, accidents. I use the accident example because it weaves together with a lot of these other components. We're in a difficult position because the juvenile law is very clear on not giving publicity to any case involving a person under the jurisdiction of that court, but we don't know the answer to that for some period of time until the investigation is concluded. So when an accident report becomes public, how it becomes public, does it have to wait until it reaches the Agency of Transportation, where it's clearly a public record, or is a law enforcement agency somehow either compelled to produce it or restrained from producing it because of the intersecting juvenile law that prevents us from giving publicity to any instance where there's a case that's under the jurisdiction of that court? It also appears that when that was drafted, the legislature was very mindful to make that a floating, I'm not so sure it was age, but it's a floating definition. So it's defined now as persons under the jurisdiction of that court. It doesn't have a particular age band. And as the legislature has continued to modernize the juvenile law and the starting point for certain types of cases where historically there was a pretty clear line of demarcation at 16 years old and at 18 years old, where a case was presumed to be in criminal court by default over age 16 and always in criminal court over age 18. That has now changed to the presumption being those cases start more often than not in the family court than in the criminal court. And the age has expanded all the way up to age 22. So it's not just traditional juvenile records that are intersected by this section of Title 33, but a more broad array of cases that are under the jurisdiction of the family court. So that's the general overview of the tension. And again, in the draft, it's just an outline. It's not testimony per se. There are a number of flags for you as you unpack this. And I won't go through each one because I'd basically just be reading this document. And I think it's probably better served to make this more interactive, Madam Chair. But I will add that there are some additional sort of contextual and operational considerations that, again, they don't want these to be taken as a position on the part of public safety, but we want you to be aware of the other tensions and issues that arise when we're talking about these cases. And frankly, the complaints we get from parents, from, in some cases, from adults, sort of parallel to this, and from counsel to juveniles as we navigate these things. So beyond those legal conflicts, there are sort of emerging operational conflicts. So I mentioned the expanding legislative goals of the juvenile proceedings all the way up to 22. There are also have been expanding legislative goals of expungement and record sealing that bang into this, and I'll explain a little bit more about that in a second. Where that actually intersects is increasingly there are online services that it's called scraping data. They go out, we issue a press release, for example, they scrape that data off the internet and archive it forever. And it's a fragment of information. So it's a press release or a news story that Jane Smith, adult or potentially juvenile, was involved in XYZ event. And it's difficult or impossible for those records to ever be fully eradicated. They exist forever, at least until some alterations are made to the way the internet functions. And I wouldn't hold out much hope that that's going to happen. So those fragments exist often in conflict with our policy goals, which are in many cases to allow for either the seal or the expungement of a record after someone's demonstrable behavior improves, or because of age or something of that nature. And that creates a variety of issues. One that we wanted to flag was that the information is being sold. And again, I'm not sure exactly how to weave that into the policy conversation, but you should be aware of it. The inability of those whose records become public to ever clear those stories or flags. There's just no way for them to ever get that information that's been scraped into a for-profit site back. And even if a record is sealed or expunged, that fragment of information may still be there, but they're unable to actually produce a record that gives the full context of what that event was, because if it's been expunged, it's largely been eradicated from public view, or entirely eradicated from public view. Which brings up a whole other area of inquiry and exploration as to whether expungement is the right way to go relative to records, or sealing them so that there is a way to either for the courts or for the individual to get access to them at a future time. So that's the satellite view of not all, but many of the conflicting and navigational issues presented, in particular by juvenile records, but to some extent, I wouldn't want to just be completely dismissive of how some of these things intersect adult records as well.
Thank you. I'm going to ask if any of the on the committee have any questions, but first I will say that the expungement issue is a huge issue, and we've been dealing with that in judiciary, and there is some thought that in many cases it's better to have it sealed than expunged. Just as you pointed out, somebody might be they might have been found, there's a charge and they might have been found innocent or something else, but if it's expunged, then there's no record. And so sometimes it's better to have it sealed. But I think that for our purposes, what I want to do is at this point anyway, focus on the, and there is an expungement bill again in judiciary that has just been introduced. And is to this conflict between the arrest records, the court records, the juvenile as opposed to the adult, and how we can deal with that. So does anybody have any questions for the commissioner at this point? And then I think we'll hear from David from the AG's office. He's the one that brought the issue to me. Senator Clarkson?
So, Michael, how have people been dealing with it? It strikes me that it must be being dealt with in a way, or this would have become an issue. I mean, this is an old issue.
It is. It's a great question, Senator. And, full disclosure, I was not fully aware until this case emerged of the nuances of the state police public information policy, frankly. And it differs dramatically from the policies of every other law enforcement agency that I'm aware of. In Burlington and South Burlington, in Chittenden County, where I'm most familiar, and I've polled other agencies as well, juvenile records are simply not made public. With the exception of tickets and accidents under certain circumstances, but there are no press releases issued on anything to do with juveniles. This policy was in place that in the Department of Public Safety and with the state police that differed dramatically from that. And the flag went up when we received, I'm not sure it was a complaint, but it was communicated to us that we're potentially afoul of the juvenile law. And that came from a private attorney and a state's attorney. And that's what threw this flag on this particular case that became the issue. So as we then unpacked the policy, I had concerns about the way that was written. So I issued what Mike Donahue, who's probably on the line now, has graciously referred to as a gag order, what is actually a hold on that portion of the policy to ensure that we're in compliance with the law. And as we unpacked that, it became clear in conversations with the Attorney General's office, with other general counsels from other agencies, that this impacts that in some instances our policy was not in compliance with the law, and in others it is ambiguous. So that's why we're here collectively to try to get some clarity.
Thank you.
Any other committee questions? Senator Polina?
Yes, I just want to back up a little bit. I want to see if I heard you right. I think you said that there's a time lag between the time an event takes place and when that person is assigned to a particular court, whether it's the family court or the regular court. I think that's true, correct? And then if that's the case, what would you normally be doing when that happens during that time frame? What's your position on how you should be reacting?
So I can give you two answers to that, Senator. The first is in the roughly 30 years I've been doing this prior to being in state government, the answer was we did not release juvenile information except again, once an accident report potentially was completed, or tickets, and upon request, and not proactively. And that dealt with the incongruity, because at that point, when you got the request, you could assess whether there was an intersection with a juvenile court or family court case, depending on how long ago you were talking. And then you could be responsive, taking all of that into account. Where the way business was being done here is that the state police issue about 5,000 press releases a year, every accident, every arrest. And that's a far different operating environment than what I came from. So that's where the incongruity came in, is that, and the issue becomes the timing of that. It's, again, I think there's clarity relative to the accident report eventually being public. The question is whether the law enforcement agency that's investigating that can or should make that public if it's a juvenile operator, before it's known whether there is a case headed to the family court for jurisdiction, or whether the law enforcement record of that accident should be public at all, given the fact that it's a juvenile, or it should just await its entry in the Agency of Transportation records and become public then. Those are some of the public policy considerations for you.
Yeah, it's a tough one. Thanks.
But other committee member have a question or concern? Yeah, I think then, well, thank you, Commissioner. And I hope you can stay with us for a little while in case there are more questions. So David, would you like to weigh in here? David is the one that brought this to our attention, and he also brought it to the attention of Senator Sears, and Judiciary is also going to look at this so that we can make sure that we get the issues around the court and law enforcement and public records all kind of working together here. So David.
Sure. Thank you, Senator. For the record, David Scher, Assistant Attorney General with the Attorney General's Office. I'd come on this afternoon expecting to elucidate the problem and explain it. Commissioner Sherling did an excellent job of doing that for me, and I appreciate that. I think the problem has been well laid out before the committee. We did write a letter to the chair, Jeanette White, as well as the chair of government operations in the House. I did have the committee staff post that to your website, so that should be accessible to you under today's date. And basically that letter lays out the problem that we've already been discussing and that the commissioner explained already, which in some, and I don't want to take up too much time since I think it's already been well explained, I'll make myself available for questions. But in summary, there is a tension between the policies of how we treat juveniles, policies that I think have compelling interest behind them in protecting young people from lifelong consequences for youthful errors. I think that's an important, very important consideration. And we also have a Public Records Act that appears to make, on its face, might make some of those records, might run, frankly, in direct contravention to the policy interests that are laid out in our juvenile laws by forcing some of those records into the public, even in circumstances where those records would otherwise, once jurisdiction of family court lies, once those records would otherwise be fully protected. And I think that that's a tension that we need to resolve to be fair both to the public's right to know and be clear on when that interest holds, and also be clear on when we need to protect the confidentiality of young people who may be subject to law enforcement records or maybe within law enforcement records. And again, I think the commissioner did a good job of laying that out, and I'm happy to answer questions. I will likely defer operational questions to the commissioner, but I'm happy to answer questions on some of the legal here.
Any questions for David at this point? Senator Collmore?
Thank you, Madam Chair. Actually, not for David, but maybe for Commissioner Sherling, or just a general question. Senator Polina talked about the lag time that sometimes occurs. I wonder if there is, by statute or policy, a period of time that has to go by or that should go by between the time of, let's say, an automobile accident and the press release or the attendant reporting of what occurred and who was involved. In other words, if you hold back, and I don't want to say that in a bad way, but if you're holding back information because there's a juvenile involved, aren't you sort of sending that message out by holding back that information for a given period of time?
That's a great question. So two things. Relative to timeline, we're obligated to deliver crash reports, accident reports to the Agency of Transportation within 30 days. And again, I'll give you sort of the bifurcated answer. The way that I'm used to doing this is if there's a serious crash, one involving serious injuries, it impairs traffic and people are snarled up for a period of time and inconveniences them, so it's a matter of public interest, or there's a fatality, historically in other jobs in public safety, we would issue a press release, but we would say it was juvenile operator, age 16 of Colchester, picking a town and a random town and a random age. We would not release the name. So the timeliness becomes less of a factor because you're being transparent regarding what happened. And then, as David mentioned, the question becomes which public policy goal supersedes the other? What's the superordinate goal? Is it relative to juveniles? Is it the protection of, I think it's referred to at one point as the stain of criminality? Or wrongdoing, or is it the public's right to know that they were the operator in a crash? And I don't want to overemphasize the crash as the only thing. That just happens to be the most complicated one where they intersect.
Thank you.
Other questions for David or the commissioner right now? So I think we'll go next to James Pepper is here with us from the state's attorney's office for kind of their perspective on this. And then I'd like to go to Pat Gable. Is that okay? Thanks. So Pepper, do you want to?
Sure. James Pepper, Department of State's Attorneys and Sheriffs. I missed a little bit of the earlier testimony, but I understand the issue. And generally speaking, by the time the records requests come to me, I am the public records officer for all 14 state's attorneys. The case is usually already filed in court, juvenile court. And so my response is always pursuant to, 55117, no record exists. But this is an issue that is going to come up again and again and again. And, there is a conflict there that I see. And there's actually another layer to this that I deal with from time to time, which is with respect to youthful offender cases that start in criminal court. And there's a number of filings, probable cause affidavits and informations. But then there's a youthful offender petition filed. And the case then is on its way to juvenile court, and then a public records request comes in that interim. I've just worked with the requesters of those records, and we haven't had to litigate the issue yet, but I guarantee you that it's only a matter of time before someone wants the Supreme Court to weigh in on this, unless there's some clarification that this committee and the legislature is able to provide with respect to this conflict. Again, the state's attorneys, usually it's pretty clear cut whether a case is active or whether charges have been filed either in criminal or family. But there is going to be this tension that exists when charges are being reviewed or an incident is being reviewed and no charges have been filed, and whether that record is public. So I'm happy to be part of any sort of working group that tries to help resolve this tension. But I don't have a straight answer as to what direction I would recommend you go at this point.
Thank you. Any questions for Pepper? Senator Clarkson?
Pepper, it is always a pleasure to see you.
Thank you.
I'm curious what our other states must have resolved this. And it's an old issue. I mean, as we know, this tensions existed for a long time. Clearly, some departments have solved it in their own ways, have just acted as they felt was appropriate. How have other states resolved it? And what are the best practices that we could turn to learn how we might proceed?
That is an excellent question. I don't know. You know, I know that we have another kind of layer to this issue with motor vehicle records for juveniles that are looking to get CDLs. And, you know, if the court sends the records, you know, this has come to a head with the kind of expansion of juvenile jurisdiction to include 18-year-olds. If the court sends the record to DMV, then the DMV will suspend the license. If the court doesn't, then they won't. And there's no real clear answer as to how we should deal with the collateral consequences with respect to CDLs, points on fish and wildlife violations. I think everyone in Vermont, and I don't know about other states, is trying to work collaboratively to figure out those types of issues. And also what colloquies are necessary to tell 18-year-olds about the collateral consequences of their actions that extend beyond, you know, usually when a juvenile case is closed, you know, it's sealed, and then a few years later it's expunged and there are no collateral consequences. But, you know, these issues are now starting to crop up as we expand juvenile jurisdiction. So I'm sorry, I don't have a straightforward answer for you. And I really don't know what other states are doing, but I can certainly think about that and try and look into that and work with, you know, some of our folks at the Secretary of State's office.
Yeah. And maybe Tucker, maybe that's something we can find out through Tucker about what other states have done to solve this problem.
Well, I think that Pepper is right that ours might be even more complicated because of our public records law is probably different than other public records laws in other states. And we're moving toward expanding the definition of juvenile. So I think it's, we can look to other states for some suggestions and hopefully can find some there. But Senator Polina?
Thank you. This is something I should know the answer to, but I'm going to ask anyway. The decision to have somebody go through juvenile court or family court or the criminal courts is based only on their age. It doesn't necessarily mean that it's a less grievous infraction because it went to juvenile or family court, correct? In other words, the implication that it goes to juvenile court in some people's minds might think, well, that means it's not that serious of an offense. That's why they're dealing with it in juvenile court. I'm not sure if that's the case or not. So I'd like to get, I've just been thinking about that. And I'm just curious what your answer is to that.
Madam Chair, is that?
Yes.
Can I answer that? Yeah.
Yes.
So age is certainly the kind of initial sorting factor between juvenile and family. However, certain crimes, certain kind of Big 12 crimes, there's some discretion within the state's attorney whether to file, you know, a 16, 17, 18-year-old or older, including, you know, the youthful offender aged folks in criminal court. So if you're talking about some of the more serious crimes that we have, they could go to criminal court as opposed to family, even though, you know, the offender is 18 or 17.
Thanks.
Any more questions for Pepper at this time? All right, so Pat, would you like to I think, have you been in our, oh yes, you've been in our committee before, many times.
Yes,
On different issues, but welcome.
thank you. And of course, this is a new year, and so technically a new committee, so it's nice to be here again with you. And a couple of you were on my on the Judiciary Committee this morning where I didn't have any access, so I've driven to the office so that wouldn't happen again. So I thought the previous speakers have actually framed some of the issues quite well. And although in some ways we might say that these issues have been around a long time, in a different way, the stakes are dramatically changed now as we've moved off of paper records and onto digital records. But before I go down that road, I could say, just for the benefit of the committee, quickly framing the difference between the state statutes and the court rules. As a result of the separation of powers, the public records law does not directly apply to the judiciary. And so when you talk about, for example, when records are in the custody of the state police or custody of prosecutors, you are still dealing with the state public records law. As soon as a document is filed or testimony is given in a court case, the applicable rule for those things that have come into court shifts to the rules for public access to court records. And the way the Supreme Court has approached public access issues as it's developed and changed rules is that to the extent that the judiciary has administrative records, which are not that different from the records that would be present in the executive branch, you'll see in the rules that the judiciary adopts by reference, not all, but most of the applicable rules for administrative records. However, with respect to case records, which are unique to the judiciary, those have been adopted by the judiciary directly. And many of you are probably aware that within the last few years, the rules for public access to court records have been dramatically changed to modernize them and to recognize the shift from a predominantly paper case file to a digital case file. Right now, the judiciary is smack dab in the middle of that transition, and it's being done on a geographic way. So that means the southern part of our state, central and southern part of our state, are now in digital records. The northern part of our state is still on paper records. And so there are different custodians and different ways those two kind of records are handled. The issue, one of the issues that was mentioned by Commissioner Sherling, which is the data scraping by for-profit entities. That kind of issue, whether you're scraping a non-mobile record or you're trying to capture some kind of video, dramatically changes the stakes in the balancing of interests that take place whenever we talk about the difference between the public's right to know and the privacy and confidentiality and personal issues regarding litigants. And Commissioner Sherling mentioned that in some cases, you can never get rid of that data. It's owned by a private entity and it'll just always be the first thing you come to on Google. In other cases, the private entity is charging people $500 and up for them to remove something from their database. And so in the judiciary, we're, as we talk about our approach to public records, should we change our rules and the like, we're always looking to the public policy that has been adopted by the legislature in not just in the access to public records law, but also in all the substantive statutes. And so you will find in Rule 5 and Rule 6 of our public access to court records rules, we have a reference to all the laws that you've adopted, because if you've adopted a law saying juvenile records are confidential, then our public access rules recognize that and enforce that. There are some kinds of cases we deal with that are unique and are not necessarily covered by your public policy. But that's why I do support the idea of perhaps a tri-branch study group or work group, which I would be happy to participate in, that really get down and look at not only the goals of this public policy and the balancing of interests, but also what kinds of technologies are being used now that the legislature would certainly want to know about and appreciate as it adopted these rules. Because even though today we're talking about juvenile records, and by the way, not all states consider juvenile records to be confidential. That in itself, is really reflects the cultures and values of the public in Vermont, our rules, and different states are going to have different rules. But as was previously mentioned, the move to try and seal and expunge records to enable people to move on from prior, unfortunate incidents really raises this in the context of adults as well. And it's the very same issue. Once something's been, taken off of an executive branch or a judicial official record and becomes owned by a private or even a nonprofit, some agency for good, it's not in our control anymore. And we get constant inquiries from people who said, look, my record's been expunged and yet it's on Google and I can't get a job. And we have no control over that. Once someone takes it off of our site or copies one of our records and makes it a commercial or private document, you've sort of lost the ability to control it. And so I'm happy to talk about the technical issues, though I think that's been covered pretty well by the other speakers. But I really do think there is a fundamental change in the balance of power. And I'm sure you have journalists who, have some very different points of view on that. But we ought to have a good conversation. So regardless of what the outcome is, everyone understands the information and the data and the issues that went into, striking that balance.
Any questions, committee, right now for Patricia? I have to admit that when Commissioner Sherling was talking to us and David was talking to us, it seemed that we might be able to craft something around law enforcement because that's kind of our jurisdiction. But it is a much larger issue, the whole thing. And so, okay, anyway, I just, it is a huge issue. I do think we might need to do some clarification around it on the law enforcement end. But at the same time, and this might be more in the judiciary's jurisdiction, is to have some kind of a like you said, a tri-branch study committee to really figure out what we're talking about with records and how we protect people and how we do that balance.
Yes, and I think what we find is we're seeing issues now as we go to an electronic case management system where what happens to documents that come into the judiciary and the responsibility to keep them sealed and all the rest of it. And so anything that looks more clearly at that transition between documents being under other custodians and then them becoming a part of the system, I think that would be helpful.
So if there are no questions right now for Pat, what I would like to do, I think, is go, because we heard from Commissioner Sherling that most of the law enforcement agencies have a different approach and a different policy than the Vermont State Police does. And I see that Sheriff Anderson is with us. Would you care to weigh in on how you approach this and what your policies are.
Good afternoon, committee. For the record, Mark Anderson, Windham County Sheriff. I'm also the second vice president of the Vermont Sheriff's Association. I do want to note the Sheriff's Association doesn't currently have a position on this. This is a direct, I'll say an isolated issue that we've noticed with the story revolving the Department of Public Safety. So we haven't taken a position yet, but certainly would like to evaluate any language proposed in the future. In terms of my personal department's experience, we haven't had to deal with this yet. And while the youthful offender statute has been in existence for a while, it seems that that common thread has not come through our needle. So to the point, I don't know that we have the answer to your question. With regards to public records requests, we generally err on the side of disclosure, which would then be counter to the issues stated by Commissioner Sherling and others. So I don't have a good answer for you, Madam Chair.
Oh, I always try to count on you for good answers, and here, anyway, okay. Thank you, Sheriff.
Thank you.
So I guess what I would like to do is hear from, I see who, Jennifer, hi. And I don't have my agenda here, so remind me what you are muted.
Apologies. Yeah, my name is Jennifer Micah. I'm General Counsel with DCF.
Okay.
Department of Children and Families.
Yep.
So I've worked in state government for many years, and I've worked through Dale, DMH, and now with DCF. And what I see is the thread of trying to create circumstances in the lives of everyday people to allow them to continue to have robust, productive lives. And, you know, in Dale, we are reducing institutionalization, and DMH, the same thing. And now, and we're also moving in that direction at DCF in trying to reduce the number of juveniles who are going through criminal court by putting them into the family court. So there's a theme running through the legislation that you're seeing in the state of Vermont generally, and that is trying to hold our citizens, not just hold them accountable, but hold them in a way that allows them to lead productive lives in the future. So a couple years ago, we passed the raise the age legislation, which places currently 18-year-olds in family court for criminal charges that they might have gotten, and it's going to go up each year hereafter up until 22. And the purpose of that is exactly what I said, which is to allow them to move on from the experiences they might have had that have been deleterious to them, to other people, to the community at large. So what DCF would like to see, I understand that there's a whole host of issues that especially Pat Gable raised around what do we do with these court records, and what about scraping, and all of this really important work. In the meantime, though, I think we can address the juvenile point. I think I would ask the committee to craft some legislation, and I'd be happy to help with that. Craft some legislation to create confidentiality at the point of contact of law enforcement, so that there's an immediate wall that goes up between law enforcement and the public vis-a-vis the information regarding a juvenile. So that's what we're looking for. We'd be happy to help you with that in any regard. I think it's consistent with not just DCF, but with Vermont generally.
Thank you, Jennifer. Any
Thank you.
questions for Jennifer at this point? Okay, I think that next we will jump over to Mike. Mike Donahue, did you want to weigh in here?
Good afternoon, Madam Chair and fellow senators. Back for another year.
Senator Mazza in our meeting the other day said you wanted to know if we could actually be friends this year, and I said I thought we were.
consider the source of the question,
Okay,
please, you know.
okay.
I've always told him you're a good friend. You know, you got upset because I shop at his store occasionally. That was.
I know. Okay, so what
So
do you
anyway,
have to say? Tell us.
I guess a couple of things. One, first, this is a bigger issue than just this one thing. I think the biggest issue, and you've done an awful lot with public records, is the inconsistency on the release of access to records in general. Just as an aside, one of the police departments refused to give out the name of a dead person that was found in town to the newspaper and everything. When they appealed to the city manager or town manager, it was upheld that they could withhold the name. But meanwhile, the death certificate is filed downstairs in the city clerk's office. So there's just this inconsistency that the police say the name's not public, but it's public in the city clerk's office. It's public in the obituary. It's public a lot of places. And there's just this inconsistency. And I could go on for days telling you about other cases like that. Number two, this really is a new issue. With all due respect to Commissioner Sherling, it's all because of the law that got passed last year that makes it mandatory that everything starts at juvenile court. I can tell you that newspapers, and by the way, I should introduce myself for the record. I'm Mike Donahue. I'm the executive director of the Vermont Press Association and longtime free press reporter, and still doing some work here and there. But this really is a new issue, and I can tell you that during my time at the Free Press, we routinely reported on juvenile cases. We didn't report on the names, but clearly when there was an episode, police chiefs and sheriffs would tell us that, and oftentimes there were vandalism cases that the town was totally interested in, that like somebody driving all over the turf field at South Burlington High School and destroying the turf field, or somebody shooting out windows, driving through town with BB guns and shooting out windows and, damaging 14 mailboxes. And, the police chief or the sheriff wanted the public to know that they had finally caught up to, this 15 and 16-year-olds that were doing this vandalism or whatever. So those have been reported in the past. What has changed is now they feel that, or some people feel that there's a complete gag order on anything that happens. And Senator Polina, you are correct. It does often depend now on what the nature of the case is. And this whole case, just so everybody's on the same wavelength, this whole issue really came up with a double fatal accident in Chittenden County here. An elderly couple was killed when a 16-year-old driver crossed the center line down on Route 7 and drove for a little while in the opposite lane and went head on into this elderly couple and killed the former town clerk and his wife. The state police did not give out the name the first day of the 16-year-old driver, just said it was a 16-year-old driver. I know several media outlets pushed the state police about the name because it is public record. The Vermont accident report, anybody can buy the accident report from that crash. The name, if a ticket had been issued, it would be public that way too. So the state police looked at state law, public records law, the juvenile law, and their own policy, and determined that they should in fact give out the name, and they did. And the next night, the Commissioner Sherling and I have sparred over whether it's a gag order or a pause in the policy. But the policy said that state police will no longer provide any information dealing with any juveniles unless they're going to adult court. So that means and I said to the commissioner, that means if there's an Amber Alert and somebody's abducted, you're not going to give that out. If somebody is in a fatal crash, you're not going to give the name of the juvenile out. If somebody's seriously injured in a crash, if somebody's lost, an overdue hunter, a skier gets lost, all that under this gag order, which we've asked repeatedly to have lifted, still remains in effect. So it does impact what is going on. Our sense was that this was a publicly licensed, government licensed driver on a public highway that caused a public accident, and that should be public. Now, if you consider the accident report as being the neutral part and just what the investigation showed, and over to the right you have juvenile court, and when things, we acknowledge, when things go to juvenile court, they're confidential, and whatever happens to this driver, we're probably not going to know anything about. On the other hand, if the driver gets a ticket, civil ticket, that is public record through the judiciary and the Vermont Judicial Bureau and everything. So I do know, in talking with several people, there are concerns that this legislation was not, well, there's problems with the question as to whether DMV, Fish and Wildlife will ever be told the outcome of cases so that they can, in fact, order suspensions of licenses for driving, essentially what would be 2 counts in adult court of careless or negligent driving with death resulting. That would be typically the charge in adult court. But because it's going to juvenile court, we're told that not even the DMV will ever be told the outcome of the juvenile court proceeding. Therefore, they cannot suspend the license. And same sort of thing with hunting and fishing licenses when people are caught jacking deer or whatever. I will tell you that there is a lack of awareness of this new Vermont law. I know that the state police didn't know about it, didn't seem to know about it. Fish and Wildlife didn't know about it. Some sheriffs didn't know about it. Matter of fact, we got a press release this week of four people, ages 18 to 22, out of Philadelphia, and they were arrested for heroin trafficking, high-speed chase, eventually crashed and arrested. Press release had all 4 names. State's attorney said you shouldn't have given out the names of the lower-aged ones because those people will be going to juvenile court for heroin trafficking. But the 22-year-old will be going to adult court up here. So we're just concerned that a crash could happen on the highway. It's a public event, and it should be public records as far as we're concerned. We've never had a problem getting accident reports in the past. I do understand, what you're trying to do about the juveniles and helping their reputation and everything like that. But the matter of fact is that it happened on a public highway, public event, and it should be a public record. So I guess I will cut it off there. I could go on forever with some other
I do
points.
have a couple
Sure.
comments and responses that, first of all, I think that an Amber Alert and a lost hiker are very different because they're not necessarily going to be charged. They're not the offender here. They're somebody that is being looked for a different reason. So releasing their names, I don't, that's a different question. They're not an offender. You brought that up, that they couldn't release those names. And that's a different question in my mind. What we're talking about here is offenders. And
Can I respond to that quickly? Just say that but the gag order says none of this will be given out. I realize that we're talking criminal, but not even an Amber Alert under the current policy. And that's why we've asked that it be lifted. That's all I was saying. Sorry.
Well, that's one of the reasons we're looking at this, is so that there can be clarification of what is actually meant. And I do, in terms of the 18-year-old going to juvenile court for heroin trafficking, they may not end up in juvenile court. They may end up in adult court because the way I understand the law, and I should understand it because I was part of passing it, is that it will start in juvenile court, but it could be shifted to adult court. The way it used to be is that it would start in adult court where it was all public, and then it could be shifted to juvenile. This starts in juvenile, but for serious offenses, and depending on, I think I'm right, am I not, Pepper, here, that for serious offenses or for certain crimes, it can be shifted to adult court.
That is correct. For the Big 12 offenses, there's some discretion with the state's attorney to decide where to file it. For those who don't know, the Big 12 are just the most serious crimes that we have, the murder, aggravated sexual assault, those types of crimes. But for all other crimes, original jurisdiction is in the family court for 18-year-olds and soon to be 19. And it actually doesn't go up to 22. It ends at 19, but through the youthful offender, which is a separate process, the family court can have jurisdiction up to the age of 22 over individuals.
Right.
I just want to clear that up.
Right. So the way I understood Commissioner Sherling to say was that when they had, or maybe it was David Scher, when they had a report that there's 30 days in which they have to report it to DMV or Agency of Transportation. And in that period of time, they just identify the person as a juvenile operator. They don't name the person. They do it as a juvenile operator. And within that 30 days, there would then be a decision about whether it was going to go to stay in juvenile court or go to adult court if it was one of the 12. Am I wrong about that? Does anybody, Pepper, am I wrong about that?
I'm not sure on that one.
It was either.
That is generally correct, Senator. It's Mike Sherling.
That's what I thought. So there is a period of time when the person isn't necessarily identified. So I think that our question is, what is the balance here? And as Jennifer pointed out, 16-year-olds and 17-year-olds can make some pretty serious mistakes. And is it in the best interest of them and society as a whole to keep those names confidential until there's a decision about whether they are to be charged in adult court or some other decision? And I think that's the crux of our little concern here, I think. Am I right about that? Because there's no way we can deal with all the scraping and the for-profit agencies and all that. They're just I believe, I'll say it here, I think there are a bunch of pariahs out there that are just feeding on people's need to feel that they are better than others so that they can look at everybody's records. I shouldn't have said that, but I did. So I see Senator Clarkson has her hands up. Senator Collimore had his hand up. Senator Collimore.
No, I yield to Senator Clarkson.
Okay, Senator Clarkson.
Thank you. I'd like to hear. I would like to hear what other states do about this, but it strikes me that Jennifer's suggestion about creating an initial point of confidentiality until it is charged or until makes some sense. And it's what the VSP has been doing. It sounds like it's what some law enforcement agencies have already been doing, which is initially protecting the identity of a juvenile actor. It strikes me that that's important until we know how serious it is, until we know what the ramifications are. But I'd also kind of like to know what other jurisdictions do with this tension and how they're resolving it. But I think that initial point of contact or is important to keep confidential for X period of time or until something happens, and we have to decide what that trigger is for it to either be made public or not.
Senator Colomer.
Thank you, Madam Chair. And I don't know whether Mr. Sherlin or Mr. Pepper would want to weigh in. I'm still trying to just understand. James, you mentioned the Big 12. And I know we've talked about this one incident a lot, but I think it does cover a lot of the aspects of why there's so much confusion. The 16-year-old that was involved in that, I assume his offense, if you will, was not one of the Big 12. So his identity, since it doesn't fall under one of the Big 12, would remain confidential. Is that what I'm hearing? Even though there were 2 people killed as a result?
So this is the heart of the conflict. Once the family court is involved, the family court rules require that any response to any record that's related to that case is no record exists. So essentially, there's this gap where, the Chittenden County State's Attorney is deciding whether to file charges or not, where the public records law says all the records related to the initial arrest of the individual shall be public. And once the state's attorney decides they're going to file charges, then the response has to be no record exists. And so it's a little bit of that's the tension that we're trying to resolve here. And I don't know if that's a helpful explanation or not, but.
No, it is very much. Now, would the fact, and I don't know whether this is true or not, but if there were drugs involved or alcohol involved, or would that kick it up a level to where that would change, or is it just clear cut that that identity would never be revealed?
Well, there's only 12, and it's actually 13, and sometimes people say it's actually more than that, crimes that would allow a state's attorney to file in criminal court. And of course, once it's criminal, then everything is public. There are certain exemptions in the public records law that protect certain types of confidential information, things that might jeopardize the prosecution or the investigation of other crimes, and all of the exemptions that are in 317. No, there's essentially a very set number of crimes that would permit a state's attorney to file in criminal court, which then would allow all the records to be public.
Okay, thank you.
Commissioner Sherling, I think I saw your hand up. And then Mike Donahue.
I think you may be clairvoyant, Senator. I didn't actually have it up, but I contemplated putting it up. I actually was just going to comment on Senator Clarkson's note from sort of one issue previous to this. What the state police were doing was not what I described. What I described in terms of the issuing a release and saying it was a juvenile record, or it was a juvenile operator, for example, and then potentially releasing the name later is what other law enforcement agencies that I'm familiar with were doing. The state police were releasing juvenile names on just about everything. And that's where we've run into this legal quandary.
Sorry, I had it backwards.
That's not surprising at all. I sometimes have it backwards.
Right. So can I just clarify what Pepper said? Are all criminal charges are then publicly identified no matter what the age is of the actor?
I
thought
there's a number of exceptions. I'm sorry. I can let you finish your question. I'm sorry.
No, my assumption is that even with criminal acts that anyone under 18 was still not public record.
No, I mean, 18 is a good marker for the vast majority of cases, but anything that happens in criminal court is on the record, open to the public, doors are open, press is allowed. So if the charges are filed in criminal, even for the youthful offender that then moved down to family, those initial records are still at least, out there.
But is it not the case now that an 18-year-old, even with a criminal case, would first go to family court, wouldn't it?
Except for those most
Except for the
serious.
13?
Yeah, right. So so those are the ones where you might see, for instance, a 17-year-old in criminal court, with on WCAX or anything else. So
If the committee wants to, I can get a list of the big 13 or the big 12, whatever number is actually used. I think we just went over it this morning. It's arson with murder resulting, aggravated sexual assault, lewd and lascivious on a child. So they are the most egregious.
I'm pretty clear on those.
I don't know, does the rest of the committee want to have that list? Because I could have,
Sure.
Okay. Pepper, could you send?
I have the list usually at my fingertips. Let me see if I can get it up here.
Excuse me, I'm not, my secretary.
I think Mike Donahue was waiting to speak.
Okay, Mike.
Thank you. Just a couple of points. So just some historical perspective. Oftentimes 18 was always the adult court. 16 and 17 for many, many years it could go either way. And it was always up to the state's attorney to figure out, which way it was going to go. But oftentimes the police would issue a citation, and the citations back then were all for adult court. So the names were usually public. Some people tried to withhold them. Caledonia record lawsuit versus James Walton, the Supreme Court decision spells out that citations were public record, and so that's why their names were in fact released, even if they were 16 or 17. I would say in this crash in Charlotte that killed the two people, the state police issued a straightforward news release. I can get you a copy, or I'm sure the commissioner can, that basically just gave, time, date, place, names, except for the 16-year-old. And it made no reference to whether there would be any court action. It just said, this is what happened, that, the car crossed the center line and drilled the second car that was southbound and so forth. So there was no judgment about court or anything like that. And following up on Senator Collmore's question, I think it's somewhat, I hate to call it ironic, but if the two people had survived, the state police could have cited that 16-year-old into adult court for 2 counts of aggravated assault. And I'm not sure we'd be here today talking about this case. So the fact that if they had survived, it would have been an adult court. The fact that more serious that they died sent the case to juvenile court.
I guess I'm a little confused here about what your concern is here. If it was just reported as an accident with a juvenile operator, is that not the way? I mean, clearly there was an accident. People saw it. The traffic was bottled up, and people know that there were some deaths. So, but it's just identifying it as a juvenile operator. Then there's a decision about whether it goes to juvenile or adult court. but I guess I'm confused here about if you're saying they should have named the juvenile?
They should have named the teenager. Why it wasn't in the original press release?
Because it was a juvenile.
16-year-old was not a juvenile. I mean, that they're on a highway driving with a license, and
I think that the move of the legislature, and Jennifer referred to this, has been to acknowledge the whole what we've learned recently about brain development and people not having good what is it called, administrative functions or whatever that is, decision-making functions. And actually it goes up to age 25. But I think that the entire direction that the judiciary is moving and that the legislature seems to be moving, because we've passed it, is to acknowledge that they really are juveniles, that and that we need to treat them as juveniles. And so I think that I understand that you would think that they should be named, but the move of the state is to treat them as juveniles and to work with them in that capacity. So, Senator Rahm?
I'm sort of sitting here quietly because I'm looking through Commissioner Sherling's, Secretary Sherling, I'm sorry, I'm used to calling him Chief Sherling, but Secretary Sherling's
Commissioner
document. Commissioner Sherling.
I think, unless you just got a promotion.
No, it's Commissioner. It was Secretary. It can just be Mike. It's fine.
I've called him Chief since college, but Commissioner Sherling, I keep seeing this phrase repeated that says to ensure that juveniles don't kind of experience the taint of criminality. And I understand taint of criminality in this lingering sense to mean that this follows them, sort of haunts them, a mistake that they made when they were young. What is still confusing me is experiencing consequences related to their action, because what I heard Mike Donahue say is that if the records are sealed and no record exists, they may not, still in the juvenile proceeding, they may have consequences like their license taken away, like their hunting license withheld or suspended. I'm confused between the taint of criminality as a sort of public record versus actually experiencing consequences for their actions. Some of the comments have confused me about what it means to not have a record exist.
I think
so. It's a great question, Senator. If I may, just very briefly, that is language from the statutes. So that's not the Department of Public Safety editorializing.
Yeah, no, I'm just like, can someone tell me when you wrote that, what that meant? And did it mean that they wouldn't experience consequences of criminality, or just not the public consequences?
I think that there are collateral consequences that go along. There are consequences, and then there are consequences. And people who, even who are in the juvenile system, do face consequences. It isn't as if they go to juvenile court or family court and then that's just the end of it and they forget about it. They might have pretty lingering consequences, but there are other consequences that follow people through their life. And I can't think of one in a juvenile. I'm sure either Pepper or Jennifer could, but just things like we had a woman who was charged with having marijuana 40 years ago. She now has grandchildren and she can't go on a trip. She can't supervise a school trip with her grandchildren. That's a kind of a consequence that is the taint of the whatever that term was.
Yeah.
And I think that we don't need to saddle people with more more consequences than they need. And because does it affect their ability to go to college, to get a scholarship, to live in public housing, to have some rental assistance, to get a job someplace, to become an attorney, to whatever those things are, those are things that follow people forever. And I'm sure Jennifer and Pepper can answer that much more eloquently than I do. Either of you want to take a stab?
I mean, I thought you did a great job. I mean, that's the state's attorneys have supported expungement. I mean, it becomes a resource issue for our staff. Just the number of expungements that we've seen come through, and I know we have a bill that I'm going to be discussing tomorrow with the Judiciary Committee in the Senate. But you know, we've supported expungement for all the very reasons that you said. You know, the criminal justice system is very good at attaching these criminal records to folks, and we need to have a very robust system to erase them when they no longer serve any purpose.
I just want to be clear. I definitely don't disagree with that. So I don't need any more clarity there, but does the DMV take their license away if they've committed a crime like this as a juvenile?
They might.
Or will be notified that this happened?
Well, they may go into diversion. I mean, there's so many ways that it's dealt with. I mean, they may go into diversion. They may have those may be conditions of whatever consequence is there. But I think you're balancing consequences with an unformed brain, an incomplete brain. And one of the things we're dealing with as a legislature is dealing with science. We always like to say we want to be science-based, fact-driven. The brain, particularly the male brain, is not fully formed until 25. So what do consequences mean to an immature brain? What does and so you're balancing all those aspects of how we deal with consequences, what they mean, what did the action mean in the first place?
I'm going to, I just realized that it is now 3:13. We were supposed to take a break, and we have another topic coming up at 3:15. So what I would like to suggest is that we take this up again. I think this is an issue that we need to address sooner rather than later. Am I right about that? Because I think that there's some pressure for us to do it. And so what I'd like to do is talk to Senator Sears and see how we navigate this issue between the two committees and put it on the schedule again for next week.
Right.
Is that, and hopefully, and everybody who's here today will get an invite to next week. And I will hope by the end of next week, by Wednesday or Thursday, that Commissioner Sherling will feel a little easier about his responsibilities and that we can move forward.
Senator White, for your, in the committee's benefit, I did send that list of Big 12 offenses to Gail and directly to you.
Thank you.
Yep.
Thank you. So does that make sense, committee here? And I thank everybody for coming. And just a word here. I know that we said we were going to start this at 2 and that some of you very diligently came to join us at noon, but we did start early. Just kind of keep an eye on it because our schedules tend to be a little bit fluid. And so if you just keep an eye on when we start, that would be great. Thank you. Okay, so committee, can we take a just a 4 or 5 minute break to let people stand up and get a glass of water or whatever you need to do, and then come back?
We need to do the stairs. You need to go exercise. Do 25 jumping jacks
or whatever you need to do. I know exactly what I need to do.
Yeah, I bet.
Okay.
So we're really just here to get a little bit of an update and a reacquaintance with the VSCA. Steve Howard is with us and Vincent Lucy is with us. Damian Leonard is with us as well. So I think we're just going to, this committee is pretty similar to what we were last year, except for the addition of Senator Rahm, which is the only new person on the committee. She's probably pretty familiar with VSCA as well. So, but we wanted to hear a little bit from you folks, meaning Steve and Vince, as to what kind of issues you see coming before us this year, and just, what your priorities are or are not. So I'll just hand it over to Steve, if that's okay.
Sure. Thank you, Senator. For the record, I'm Steve Howard. I'm the Executive Director of the Vermont State Employees Association. Thank you for the opportunity to go through our legislative priorities that will likely be in the jurisdiction of the Senate Government Operations Committee. The first issue I think that I would highlight is our members' commitment to a sustainable retirement system that protects retirement security. We are, after all, living in a state that has the worst retirement savings of any state in the country. So we are steadfastly supportive of a defined benefit plan, as is Treasurer Pierce, who is nationally recognized as an expert on pensions. And we will vigorously oppose any effort to reduce the retirement security of state employees by moving to a less secure, risky, and more costly defined contribution plan. Having said that, the unfunded liability that is part of the equation with the retirement system is a very serious concern for state employees. And we have been in discussions with the treasurer for quite some time, talking about potential solutions to ensure the sustainability of that system. One aspect, sort of principle of the state employees, the VSEA, is that this unfunded liability not be fixed solely on the back of employees, particularly in the middle of a pandemic, particularly when they are on the front lines of the pandemic. So we are going to be seriously pushing for the legislature to adopt a dedicated revenue source. We are strongly supportive of Senator Hooker's proposal to have a 3% income tax surcharge on the wealthiest Vermonters that would sunset once the unfunded liability is paid off. So we'll be supporting that. And I think that's a big area of concern that we'll be watching throughout.
Steve, when you said you have the worst retirement system, did you mean the system itself, or did you mean the benefits it provides the workers?
No, the state of Vermont, not the government of Vermont, but the entire state.
Okay.
Has, if you take the entire population of Vermont, we have the worst retirement savings of any state in the country, which is particularly a problem for women, because women live longer than men, generally. And if they don't have a sustainable retirement system, a secure retirement system, they end up in poverty. So we want to make sure that we don't make the problem that's already the worst in the country even more severe by damaging the retirement security of state employees, particularly some of them, many of them who have given nearly 30 years of their life to public service.
I think Senator Clarkson has a question.
By what metric are we the worst in the country? I mean, when you say we're the worst in the country, what does that mean? That VSEA employees are put the least amount in and get the least return? What do you mean the worst?
This, not VSEA employees exclusively, but Vermont residents have saved the least of any state for their retirement.
That's
so
different than
your constituents, whether they work for the state of Vermont or they work for, Walmart, or they work for whomever.
Right, but we're talking about VSEA pensions, not the general public's pensions.
Exactly. So our position is that the state government shouldn't do anything to make the situation in the state of Vermont even worse by doing anything that would damage the retirement security of state employees. Does that make sense?
Yes.
Good. The other thing that we're really on the retirement front, we're going to be pushing aggressively for, and this committee passed last year, is something called the California Principle, which is really the practice of the state, and it has been, the legal precedent since the Burlington firefighters decision that says that when you vest in the state retirement system, you're entering into a contract with your employer, and that benefit can't be arbitrarily changed once you retire, unless you can prove to a court that the system is collapsing and you're taking measures to save the actual pension system. That has been the practice in Vermont for forever. And VSEA, in fact, had some research done by just an up-and-coming attorney at Langrock, Sperry and Wool back in 2000, I believe it was 2009. Her name was Beth Robinson. And she said basically that Vermont has operated under this California principle, and that we ought to codify that and make that part of the statute. So that's something that we're going to ask you to do again this year. You'll remember the discussion about arbitration and settling disagreements with the administration over contract negotiations by going to a neutral arbitrator rather than going to a politically appointed labor board. That is working very well in the executive, and we thank the committee for its leadership in passing that bill. We are going to be asking this year that you pass the bill that you passed last year in exactly the same form that would expand arbitration to our members in the judiciary, who would also like to have the ability to go to a neutral arbitrator if they can't come to an agreement at the table, rather than a politically appointed labor board.
Maybe you can remind us why we didn't do that in the first place.
You did do it last year. You passed it. It got over to the House, right, I think in the first week in March, and then we all ran for the hills.
But we didn't include judiciary?
We didn't include judiciary. The reason for it was because at the time we were doing the executive, we were running out of time in the legislative session. And we knew that the leadership of the judiciary was going to oppose it. And so we didn't want to do anything that would limit our ability to at least get it to the executive, where where the labor board had been a pretty significant issue.
But in the end, we didn't pass it at all. Meaning the Senate passed it, but the legislature did not pass it.
The expansion of the judiciary passed the Senate, but it did not pass the House.
Okay.
I think it would have passed the House. They passed the expansion of the executive, the expansion to the executive branch pretty handily. They just ran out of time in the 1 week in March, or the 2 weeks in March where we were still in session. The legislature was still in session. So I don't expect it to be a very controversial issue over there at all. And I hope that it's exactly the same bill that you passed last year. So hopefully it'll pass through the Senate fairly easily. You've heard me talk about this issue before. It's becoming an increasing problem, which is the issue of privatization and the very weak statutes that Vermont has around privatizing state services. The statute we have now calls for a 10% increase if one state job is lost. There are a couple of problems with that. One is a 10% savings by privatizing state jobs if one job is lost. The administration knows its way around this law, and previous administrations, Democrat and Republican, have also found their way around it. The way they privatize state services en masse is that they close a facility, riff all the employees, and then go to a private contractor. And so what we want, and the other thing that they do is, rather than hiring additional state employees and having Vermonters taking calls, for instance, on unemployment compensation, or doing in these years of COVID, doing hiring more Vermonters to do what's the word I'm trying to say? Contact tracing. There, I got it. We are hiring a firm in Chicago called Maximus. We use them in DEVA, in the realm of healthcare. Our members will tell you that it would save the state money if we didn't use Maximus, because they, as state employees and subject matter experts on the work they do, spend more time correcting the mistakes and the failures of Maximus, as many of your constituents experienced with unemployment in a very frustrating way. But this administration loves Maximus, and they love private corporations. The level of service your constituents are experiencing is suffering, and that's all because bargaining unit work is being moved out of the bargaining unit. And so we want to make that the definition of privatization. We also want to strengthen the enforcement of the law, so that when a corporation says, yes, we can do it cheaper and better, that there's some actual assurance that that means more than just in year one of the contract, but for the life of the contract. And we also want to make sure that employees aren't the ones paying the price for the savings that a private contractor promises. What generally happens in privatization is state employees lose their jobs. The private corporation hires people at very reduced wages, doesn't provide health care, anything, or retirement anywhere close to the benefits state employees receive. So we're encouraging more working poor to provide, in the interest of providing state services to Vermonters. We're actually hiring people at lower wages without benefits, which is really contrary, I think, to the public policy the legislature and the state of Vermont have set. So we're going to ask that the Government Operations Committee strengthen that privatization law and really stop the moving of bargaining unit work out to private corporations like Maximus. Safety and security. You've heard me say this before. Since Lara Sobel's tragic murder in Barrie, which is something that the Department of Children and Families was warned about, nothing, literally, other than what's happened in the Department of Children and Families, nothing has been done to secure parking lots. There are state office buildings where you can just walk in off the street. There's no security whatsoever. There are numerous security and safety problems. And as we've seen with recent events that occurred, obviously, in Washington and other events that have happened across the state, we believe your constituents have the right to security in state office buildings. We believe that it should not be a work site. A state office building should not be a place in which employees feel danger and they feel threatened. So we want to end the use of Securitas, which is a private corporation with non-law enforcement employees carrying guns in our courthouses, in some of our courthouses in Vermont. We want to end the use of Securitas in state office buildings. We want to make sure that every building has access to trained equivalents of law enforcement officers who are state employees and accountable to the state of Vermont to secure the buildings where state employees work.
So, Steve, is Securitas? I never heard of Securitas. It sounds similar like Maximus.
Yes.
Is that something that came to be after the disastrous outcome of the Laura Sobel case?
No.
Or is that something that's been going on for a while? Like, where did that come from?
It came out of a fight between the court administrator and the sheriffs. When she decided, the sheriffs basically decided that they could not provide security or would not provide security in courthouses any longer because they were losing money on those contracts. And so the answer to that was, rather than hiring state employees, was to hire a private corporation named Securitas. Our members will tell you that they're very unreliable, that they're not adequately trained. They sometimes don't show up. And when you're dealing with an issue of security, you can't have that. The Bennington court, for instance, the civil court in Bennington is operating at reduced hours because they don't have enough security personnel to make sure that that court is secure. So we have a proposal that would create a state security force, much like the Capitol Police, that would allow for trained law enforcement officers who have been trained on how to de-escalate, know a lot about how to handle situations as they arise, The training is level across the state, so we know everybody's getting the same training. And it's also an agency that's accountable to the state of Vermont, to the folks who work in that building, to the management in that building, and not to some other entity that may not be on site. So that's a very important issue for state employees. The other issue that's part of the safety and security bill is we would like to see an independent director of safety and security. We've had some great directors of state safety and security who have whisper in my ear, here's what we need to do to make state employees safe, and here's how much it's going to cost. And boy, would it be nice if I didn't work for the Secretary of Administration who just squashes it. We need somebody who can come to the legislature, say, I'm a security professional, this is what we need, this is how much it's going to cost, and I'm not going to get involved in the politics of the issue. So that's, we create in our proposal an independent entity that is going to be focused on professionalizing safety and security and taking the politics out of it. Finally, we have a bill that we are going to be pursuing that really is a bill that came to us from the deputy sheriffs who do transports for the state. It's very similar to the issue that some of the folks who have been on GovOps for a while remember around the state's attorneys, and about the time that we came to talk with you about the desire of the employees in the Department of State's Attorneys and Sheriffs to become part of our union, and they have become part of our union. There is a group that's very similarly situated to those employees, and those are the deputy sheriffs who do the transports for the court, the judiciary, basically, who move offenders from facilities to their court hearings and back to the facilities. Those transport deputies almost unanimously asked that they become part of the VSEA, part of our non-management unit, after a recent Supreme Court decision that said that they are in fact classified state employees. So we would like to clarify their status. It is going to require a small change to the statute, and it would allow them to vote it would allow them to become members of the VSEA should they choose to. So that's my long list. The only other thing that I would add, I meant to mention this during retirement, and Senator White has been part of these discussions in the off year on the Law Enforcement Retirement Study Committee. We have and continue to have a major staffing crisis in the Department of Corrections. Our members are breaking down. They are exhausted. They are being virtually abused because we cannot retain correctional officers to work in the correctional system. Their mental health is suffering. And it's really sort of cruel and unusual what we're doing to our correctional officers by the sheer volume of overtime that they're required to work. There has been some discussion with the commissioner about the need to professionalize correctional officers, to really increase and improve hiring standards, which we 100% support and have asked for years. But that also means that we have to, if we're going to make it a career, that we ought to look at it more like we look at law enforcement officers who have a mandatory retirement age of 55 because of the physical demands of being a correctional officer, particularly in the facilities that we provide, which are not great in many cases. The physical demand of that job is just something that somebody who hits 55 they start to feel the impact of that, and their ability to do the job and do it well is hindered by their age. So they are asking for a system to be set up in the retirement system that is comparable to Group C that we have for law enforcement officers. We call it at VSEA Group G. that wouldn't be exactly the same as Group C, but would have the same kind of incentive for early retirement if you stay in the career as a correctional officer for a certain number of years. We have a carve out on the books now, but we want to make it a system similar to what our law enforcement officers have. And I think that is our laundry list of priorities for government operations, at least.
Vince, do you want to add anything? I'm sorry, did you have a question, Keisha?
I think that's a great starting point. Let's see if
Vince, do you have anything you want to add at all? We can't hear you.
Can't hear you, Vince.
Okay, how about now?
Now we can hear you.
Okay, great. Good afternoon. Nice to see you all. Welcome back. Congratulations on your appointment to a great committee. The only issue I think Steve forgot to bring up was the defensive weapons bill. It's been introduced now for the last 4 or 5 years. It remains an issue for our field force units, the officers who go out in the field. Some may remember it as FSU, the Field Service Unit, but it's no longer called FSU, but it includes many of the same job functions. They are the individuals who interact with those on probation, parole, and furlough in apartments and homes and in the community. And often the offenders are in the company of others, and sometimes they or those who are with them are under the influence of substances and may have dangerous or deadly weapons. And when you have a combination of one or more of those factors, alcohol, drugs, mental illness or disability, it sometimes results in a fairly dangerous situation for those who go out in the community. A number of other states allow our probation and parole officers, our field units, to carry defensive weapons. The bill has been considered in the past. It's gone to various committees, and our legislative committee has asked us to advance it again this year, so it may be referred to your committee or to perhaps institutions, but in any event, that is another issue that we have on our priority list. The only other item, go ahead.
Well, I just want to be clear. So we actually, we prohibit them from carrying weapons?
Well, they're not authorized, so
Right.
I think whether it's they're prohibited or not authorized, when they're on duty, they're not authorized to carry defensive weapons. They're given handcuffs and mace or pepper spray, but not anything else. And oftentimes they face people in these homes who do have weapons, and there have been some very dangerous situations that by the grace of God have not resulted in serious injury or death to some of our corrections officers in the community, in the field.
Senator Clarkson?
Yeah, I have sort of mixed feelings about that. I'd like to hear from the field. I mean, I think I only see that as escalating the problem, not helping it. And have we had any accidents? I mean, have we had injuries? Have people? I don't think anybody's been killed in this circumstance, which would be horrible. But I mean, to me, that just is adding more to a tinderbox.
Well, that has been.
I have a lot of concerns about that.
No, I understand. That's been obviously one of the countervailing arguments. If you hear from the members, I think they probably can better describe in color what they confront in some of these very volatile and unstable situations.
I get the situations they're in. I mean, I've talked with the great people in Hartford, Bill Soul's team, but I don't know that our fighting fire with fire is, it just strikes me that makes it a little even more worrisome. So anyway,
Well,
I'd have to be
that's
convinced.
clearly the debate that takes place. I hear you, Senator Clarkson.
Right.
Whether we're de-escalating or escalating, we don't want to be escalating.
Right. Well, they're trained to do all the de-escalation and to withdraw. And sometimes that opportunity does not present itself. They've been told in response to the unique situations that have occurred, and I just don't have them committed to memory, call the police. But when you're in, Canaan or some rural area where law enforcement could be up to 45 minutes or an hour away, it's just not an option.
Senator Collmore, I'm sorry.
I'd say the other thing is there's two things about it. One is these are defensive weapons, so they could not use the weapon for any other reason other than to defend themselves when they're being fired upon. And we can provide some accounts actually from Springfield where this is originated, where there's been a lot of gang activity and where they have felt really outnumbered. And in fact, there is a situation in Springfield where I remember the Springfield Police Department accompanied state employees to a home where they were enforcing the court orders, probation, and the orders that the court basically laid out for the conditions of probation. And the law enforcement officer said, "We're not going in there. It's too dangerous. We won't go in there." And they have weapons. So armed with mace and handcuffs, our members went in there. And really, I think they can tell you more about what they found, but it was not a good situation. So that's an example, Senator, from your district that we would be happy to have them share with you.
Senator Collmore, did you have a question still?
Yes, thank you, Mr. Vice Chair. I think if I'm remembering correctly, I supported this bill last year, and I would support it again this year. If I'm also remembering correctly, they receive training to the level of our law enforcement people. Is that not correct?
That's right. They would be required to go through the Vermont Police Academy.
Yeah.
The irony is that we have transport deputies now. They're not the transport deputies we referenced a few minutes ago, but rather correctional officers who transport inmates or detainees under federal custody. Part of our contract with the U.S. Marshal Service is that they have to be armed, and they take that very course you just mentioned, Senator Collmore. And it's I understand, that the police academy has a comprehensive training program from soup to nuts, but the component that the officers who do carry weapons to transport offenders take that same training. So they don't have the full soup to nuts to become a law enforcement officer, but they do train on the use of those weapons. And they have a training protocol that the department uses and has been without incident.
Thank you.
Senator Rahm, do you have a question? You're muted.
You're muted.
Yes, nice to see you both. I have a few questions. First, for the bill that you mentioned, Senator Cheryl Hooker has introduced, do you have a rough fiscal impact for that, about how many years at 3% on the highest income earners it would take to close that gap? Can you share that?
Well, I would say this: the revenue estimate is that would raise an additional $75 million, roughly.
A year, or
$75 million a year.
3%.
The tricky part is, I think Treasurer Pierce would have to provide that information, because once that money is invested in the retirement fund, compounds. So it would require an actuarial analysis to explain exactly how much of the unfunded liability it would reduce.
Mm-hmm. My second question is, this doesn't have to be something you share right now, but I would love to know if VSEA is tracking the number of Black, Indigenous, and people of color identifying staff that are state employees and their well-being, the ways that you're supporting them as a union. Can you share some of that or come back with that information?
Sure. That information is actually the Department of Human Resources. You're going to hear about this a lot.
Mm-hmm.
The Department of Human Resources tracks that in the workforce report, basically. It's an annual report that's updated. It gives you all the statistical information about state employees, and all of that demographic information is also in there. The VSEA has recently revived a diversity committee that has been long dormant and it existed on paper but never really functioned. And so they are beginning to get trained and are hoping to start working on the issues of diversity in state government and the issues that employees in protected classes in particular face as state employees. Our president is very committed to this issue, and actually I just saw an email where she is planning to sit down with Susanna Davis and work with her on trying to address some of these issues just from a personal perspective. But she's the president town has made it, our new VSEA president has made this a major priority of hers, particularly working with this new diversity committee.
Thanks. My last question for now is, does the VSEA have a position on the trooper who's been suspended for supporting the violence in the Capitol? And how would you be treating that moving forward?
So we don't represent this trooper. This trooper is represented. We represent the lieutenants, but we don't represent this particular trooper, and we don't know. We don't have a position as a result, and I just don't know enough about what's happening other than what I read in the newspaper, and I don't know whether that's. I have no idea what his case really is.
Senator White, welcome.
Thank you. Thank you. I got my bill off to Secretary Bloomer, I think. Did you bring up, I'm sorry I missed the first part of it. I was dealing with some technical issue here. Did you talk about temps? Did you bring that up as a?
No.
I didn't, Senator. Thank you for reminding me.
He was waiting for you.
That's one of the few that I'll support.
Well, then I'm going to take this bill. I'm not going to give this one to Vince. That's for sure. So we do have we've been doing a lot of work on temps, and you've heard me describe it as the abuse of temps in state government. And recently we got a decision by the labor board that was in our favor, that found that there were about 12 positions in the judiciary. And you remember the administrator testified that they don't use temps in the judiciary, but somehow they're there. And the labor board found that these temporary employees who had been there for quite some time, I don't have all their years of service as temps right in front of me, were actually limited service employees and should be in the bargaining unit, and should be entitled to the benefits of being in the bargaining unit. So that decision basically sets up a similar issue in the executive. And what we would like to do is take a look at how that would apply, how the standard that the labor board set for the judiciary would apply to employees in the executive. Basically, what we're asking the legislature to do while we go through that process is some basic human rights for temporary workers. They should have some sick days in addition to what the law requires. They should have some paid time off. They should have access to, family leave. They should have just cause protection. They should have, some of the basic rights that state employees have. Because this is something I've said a million times before. We're not Walmart. We are the state of Vermont, and we should set a higher standard. So we will be asking you to pass what we call the Temporary Workers Bill of Rights, and we'll have that legislation ready for you.
Thank you. Any other comment? Oh, good. Senator Rahm.
I just want to flag for both of you, we didn't talk a lot about what customer service has or hasn't looked like in the pandemic. But I've had a lot of anecdotal reports about deep challenges accessing information in other languages through state employees. So I just want to, as you make diversity and equity a priority in your work, I want to flag that for you, that it would be really great to have VSEA's partnership and cooperation in working to ensure language access for all Vermonters.
Yeah, that's a good point. Appreciate that.
Yeah.
Any other comments or questions?
No.
Senator White, you okay?
I do have one other point I wanted to bring up if there are no other questions at this moment.
Sure.
And I'm not asking, it's not on our, I'm just giving you an update. During the last legislative session, the General Assembly provided funding for hazard pay for the private sector. And it was the understanding of at least myself and others that
Vince, I'm just going to interrupt you because we're not allowed to talk to the legislature about hazard pay.
Right. I was just going to give I said I wasn't asking for anything, but I was just giving an update. But it's up to you. I can defer on that.
I would defer on that.
Okay, so
we're not allowed to talk to the legislature about issues that are bargainable.
Okay. Okay. Well,
bargainable.
Anyway.
We work really hard to have you guys well paid, so you didn't need hazard pay. Hazard pay was for people who weren't earning a lot either on the front lines, and we work really hard getting you guys paid enough so that isn't the case for you.
Sadly, it is the case for some. Still, even with all of that, there are still employees who would qualify for the hazard pay that the private sector received, and they're employees of the state.
But we won't be talking about that.
Got it.
But
Got it.
I am going to bring
Senator White.
So this isn't about hazard pay in particular, but it is about related to COVID. And we have a rollout policy for the vaccines. And I'm very concerned about both inmates and corrections guards, because that's not only a vulnerable population, but it's a population, in my mind, much like those people in nursing homes or assisted living facilities. They have no choice. They can't leave and they can't stay home. So what have you heard in terms of where the corrections workers and the inmates fall on the rollout?
I'm glad to hear Senator, that you have a plan, because we've heard absolutely nothing. We've heard virtually nothing. We've had some outreach from some folks in corrections about potentially joint education about the vaccine. There are some folks out there, and state employees are not immune from this discussion, who are concerned about the politics of the vaccine and the rate, the speed at which it was developed and all that stuff. So there was some outreach by the Deputy Commissioner of Corrections about doing a joint education campaign around vaccinating. But other than that, we have heard almost nothing from the administration on vaccinations.
if I could just segue a bit, last week, and I don't know if it's still the case today, 4 of the correctional facilities were on lockdown, and 8 individuals at the Vermont Veterans Home tested positive. I think those numbers are accurate. Are they, Steve?
Yes, I believe there's seven employees at the Vets Home and 1 vet.
So, just food for thought. These are vulnerable workplaces, if you will.
Sure.
Well, I don't know what our role is in in the rollout, and I don't know that we have any role, but I, for one, would feel comfortable advocating, even as a committee, advocating for the early vaccination of people who are incarcerated and who work as a correctional officer, because I mean, they go home to their families, and then their families are vulnerable, and they have children in schools, and I'm very concerned about that.
And Senator, I want to correct something. That one thing that I said while you were talking, I was thinking the vets home has also alerted us that they are vaccinating staff.
Well, that's because they're a nursing home.
Right.
Yeah.
So that's the other, so I misspoke when I said we'd only heard from this one entity in corrections. I will say that the administrator of the vets home has alerted us that they will be vaccinating our members at the facility.
Sure, because they're a nursing home, so they are following those guidelines. But I don't know how the rest of the committee feels about that. But I think
when people are committed to working in a confined environment like that, that makes them very vulnerable. And like you said, bringing it out into the community, to their families and whatnot, it's a pretty serious situation.
What's the total population of who you're talking about, Senator White?
I can tell you right now that as of today, there are 1,286 inmates in state, 184 out of state. There are 1,208 males and 98 females as of today.
Okay.
So if you're talking about 1,200 vaccines for the inmates, and then, or about 1,400, and then I don't know how many people there are that work in the prisons that have contact with them. I mean, I'm sure there are some administrators who don't actually interact with the prison population, but I don't know how many that is.
Roughly it's a little over 400.
So you're talking about less than 2,500 vaccines.
Mm-hmm.
I guess I would support that. I'm hoping to get my own too.
Yeah.
Senator, can I add?
I think congregant settings are really our challenge, and the more vaccinations we can do in congregant settings, the better, whether it's corrections or old folks' homes. I mean,
but we're doing old folks' homes.
Right. So I think all the other congregant settings are critically important for us to vaccinate ASAP.
I don't know, we have an apartment in our house, and the woman that lives in the apartment is 70, and Bill and I are both over 75. So we qualify as an old folks home.
Do you have does that count as a critical mass? 3?
I don't know, but we are an old folks home.
Steve, did you have something else you wanted to say?
I just had one, Senator Clarkson. I can't resist sharing this with Senator Clarkson because this is a major priority. The VSEA has been pushing the coalition of labor unions that we work in tandem with, Working Vermont, to work on legislation that would make the General Assembly more accessible to Vermonters who don't have a lot of means or who are not wealthy or retired. We love the legislators who are there, but there are a lot of legislators who have come to us, folks who would run for the legislature, members of the unions who can't afford to do that. So that we are going to be supporting legislation that would create a subsidy of sort for folks who fall below the median state income and want to serve in the General Assembly, and trying to also make it affordable for candidates who want to run for statewide office, similar to the way the federal law works. So I just thought I'd mention that because I know affordability and access to the legislature by working Vermonters is a real problem, and it's a discussion we've had many years in your committee. We also would like to see at some point legislators have the same benefits as state employees.
Oh, wouldn't that be nice?
Yeah.
Or how about just earning the median income? That would be good too.
How about minimum wage?
Right.
Yeah.
We think personally, we think you should all sign union cards and we should bargain for you.
I think we're ready to bargain with you. You're so successful on most of the things you negotiate for.
But we think that's a real priority, and maybe it won't pass right away, but we do have to start the conversation. Vermonters really.
Sure.
So can I just ask and go back, Senator Polina?
You may.
Okay, so I had suggested that perhaps as a committee, we might encourage the administration to prioritize. And I thought I heard Senator Collmore say he could go along with that. Can I do that?
I did say that, yes.
I'm asking the rest of the committee
What are you asking permission to do?
to write a letter to the administration from, supported by the committee, just asking them to really look at the prioritization of people in our correctional facilities who are either there as prisoners or there as
Employees.
who have ongoing contact with the population.
Yes. Oh, I'm sorry. I thought we had supported you. I think that's a great idea.
Sure.
Okay, I'm going to do it then. I'll send a note to Kendall and Dr. Levine right now.
So if there's no other questions or comments, we can wrap up. Allison?
So Jeanette, I just suggest you also add Beth Fastigi.
Okay, I will. So committee, tomorrow, just for your information, we are going to tackle, as you know, all things elections. So I'm hoping that we won't get, we have one elections bill right now in our committee, and that's just around curing or correcting or whatever you say, ballots. But the way I would like to do it is to just have a rundown from the Secretary of State's office about what was good, what went wrong, what could be changed, some of the issues, and then hear from the other groups like the League of Cities and Towns, the Town Clerks Association, the Campaign for Vermont, VPIRG, the League of Women Voters, anybody out there, and just get all the ideas on the table and then start looking at those ideas instead of tying ourselves into one or two bills. And I think Anthony is going to put a bill in, and I think Chris Bray is putting a bill in. I don't know how many others we'll have. Does that make sense?
Always.
Okay, so we'll have the tomorrow.
Okay.
Steve, Vince, thanks for stopping by.
Thank you.
Yeah,
We'll be in
it was
touch.
good to see you. Good to see you both.
Have a great
Thank
year.
you, everybody. Thank you,
Bye-bye.
Anthony. Rockin' job.